Hello viewers, today we will discuss the topic interception and monitoring of electronic communication. Internet has opened up a new medium for exchange of information among users. Every second of millions of messages are being created, sent and accessed. We are living in the information driven world. Information is like a sword, it cuts both the ways. This free flow of information has the capability to even affect a state's both internal and external security, which may include its sovereignty and integrity, defenses, security, friendly relation with foreign states, public order, incitement to the commission of any cognizable offence or for the investigation of any offence. Thus, it is imperative for any country to listen to the electronic communication for the larger public good. It should not be forgotten that survival of a modern nation state depends on how effective its regulatory framework is. There has to be a balance between constitutional guarantees and the scope and extent of the protective measures. Law on interception in India derives its strength from the Indian Telegraph Act 1885. Section 5, subclause 2 of the said Act provides on the occurrence of any public emergency or in the interest of public safety, the central and the state government may, if satisfied that it is necessary to expedient so to do in the interest of sovereignty and integrity in India, the security of the state, friendly relation with foreign states or public order, or for preventing incitement to the commission of an offence for reasons to be recorded in writing by order direct that any message or class of messages to or from any person or class of persons or relating to any particular subject brought for the transmission by or transmitted or received by any telegraph shall not be transmitted or shall be intercepted or detained or shall be disclosed to the government making the order or an officer thereof mentioned in the order. This section mirrors under what circumstances the central government or state government shall intercept any telegraph. Moreover, section 7 subclause 2b provides for procedural safeguards application to section 5 subclause 2 of the Act. In fact, it was in R.M. Malkani versus State of Maharashtra wherein it was held. Article 21 contemplates procedure established by law with regard to the deprivation of life or personal liberty. The telephonic conversation of an innocent citizen will be protected by the courts against the wrongful or high-handed interference by tapping the conversation. The protection is not the guilty citizen against the efforts of the police to vindicate the law and prevent corruption of public servant. It must not be understood that courts will tolerate safeguards for the protection of the citizen to be imperiled by permitting the police to proceed by unlawful or irregular methods. Furthermore, the Supreme Court issued procedural directions to be followed by the competent authority for initiating telephone tapping. An order for telephone tapping in terms of section 5 subclause 2 of the Act shall not be issued except by the Home Secretary Government of India, the central government, and Home Secretaries of the state governments. In an urgent case, the power may be delegated to an officer of the Home Department of the Government of India and the state governments not below the rank of Joint Secretary. Copy of the order shall be sent to the review committee concerning within 1 week of the passing of the order. The order shall require the person to whom it is addressed to intercept in the course of their transmission by means of public telecommunication system such communications as are described in order. The order may also require the person to whom it is addressed to disclose the intercepted material to such person, and in such manner as are described in the order. The matters to be taken into account in considering whether an order is necessary under section 5 subclause 2 of the Act shall include whether the information which is considered necessary to acquire could reasonably be acquired by other means. The interception required under section 5 subclause 2 of the Act shall be the interception of such communication as are sent to from one or more addresses specified in the order, being an address or addressee likely to be used for the transmission of communication to or from one particular person specified or described in the order, or one particular set of premises specified or described in the order. The order under section 5 subclause 2 of the Act shall, unless renewed, cease to have effect at the end of the period of 2 months from the date of issue. The authority which issued the order may at any time before the end of 2 months period renew the order if it considered that it is necessary to continue the order in term of the section 5 subclause 2 of the Act. The total period for the operation of the order shall not exceed 6 months. The authority which issued the order shall maintain the following. The first one is the intercepted communication, then the extent to which the material is disclosed, then the number of persons and their identity to whom any of the material is disclosed, the extent to which the material is copied, and the number of the copies made of any of the material. The use of the intercepted material shall be limited to the minimum that it is necessary in the term of section 5 subclause 2 of the Act. Each copy made of any of the intercepted material shall be destroyed as soon as its retention is no longer necessary in term of section 5 subclause 2 of the Act. There shall be a review committee consisting of Cabinet Secretary, the Law Secretary and the Secretary Telecommunication at the level of the central government. The review committee at the state level shall consist of Chief Secretary, Law Secretary and another member other than the Home Secretary appointed by the state government. The committee shall on its own, within 2 months of passing of the order by authority concerned, investigate whether there is or has been any relevant order under section 5 subclause 2 of the Act, where there is or has been an order, whether there has been contravention of the provision of section 5 subclause 2 of the Act. If on an investigation the committee concludes there has been a contravention of provision of section 5 subclause 2 of the Act, it shall set aside the order under scrutiny of the committee. It shall further direct the destruction of the copies of the intercepted material. If on investigation the committee comes to the conclusion that there has been no contravention of the provision of section 5 subclause 2 of the Act, it shall record the finding to that effect. Spurred by the court's direction, Rule 4919A was inserted in the Indian Telegraph Rule 1951. Subsequently, the Indian Telegraph Amendment Rules 2007 amended the Rule 419A from the point of view of further procedural clarity. The Information Technology Act 2000 and Interception of Electronic Communication. As articulated above, interception of any message or class of messages are regulated under Indian Telegraph Act 1885. However, a piquant situation arose with coming into effect of the Information Technology Act 2000, as under this Act, the controller of certifying authorities had been given the mandate to intercept any information transmitted through any computer resource. Direction of a controller to a subscriber to extend facilities to decrypt information, it's defined in section 69. If the controller is satisfied that it is necessary or expedient so to do in the interest of the sovereignty or integrity of India, the security of the state, friendly relations with the foreign states or public order, or for preventing incitement to the commission of any cognizable offence for reasons to be recorded in writing, by order, direct any agency of the government to intercept any information transmitted through any computer resource. The subscriber or any person in charge of the computer resource shall, when called upon by any agency which has been directed under subsection 1, extend all facilities and technical assistance to decrypt the information. The subscriber or the person who fails to assist the agencies referred in subsection 2 shall be punished with an imprisonment for a term which may extend to 7 years. The aforesaid section had made the controller the sole statutory authority under the Act to direct any agency of the government to intercept any information transmitted through any computer resource, which includes computer system, computer network data, computer database or software. Section 2, subclause 1K. In a way, Section 69 extended the provision of Section 5 of Telegraph Act 1885 into the world of electronic communication. Unlike Section 5 and Section 7 subclause 2B of Indian Telegraph Act, read with the Rule 419A, a different competent authority was assigned the task of interception. There is the controller of certifying authorities under Section 69 subclause 1. If the controller is satisfied that it is necessary or expedient so to do in the interest of sovereignty and integrity of India, the security of the state, friendly relations with the foreign state, or public order for preventing incitement to the commission of any cognizable offence for reasons to be recorded in writing, by order, direct any agency of the government to intercept any information transmitted through any computer resource. Nevertheless, the common ground of interception, whether under Indian Telegraph Act 1885 or the Information Technology Act 2000, has been that the competent authorities under respective legislation were empowered to pass an order of interception after recording its satisfaction that it is necessary or expedient to do so in the interest of sovereignty and integrity of India, the security of the state, friendly relations with the foreign state, public order, or preventing incitement to the commission of an offence or cognizable offence. When any of the 5 situations mentioned above occurs to the satisfaction of such competent authorities required, then the said authority may pass the order of interception of message by recording reasons in writing for doing so. Powers to issue direction for interception and monitoring or decryption of any information through any computer resource is defined in Section 69 of IT Act, where the central government or state government or any of its officer specially authorized by the central government or the state government, as the case may be, in this behalf may, if satisfied that it is necessary or expedient to do in the interest of sovereignty or integrity of India, defense of India, security of state, friendly relation with the foreign states or public order, or for preventing the incitement to the commission of any cognizable offence relating to above for investigation of any offence. It may, subject to the provision of subsection 2, for reasons to be recorded in writing, by order, direct, decrypt or cause to be intercepted or monitored or decrypted any information transmitted, received or stored through any computer resource. The procedure and safeguards subject to which such interception or monitoring or decryption may be carried out shall be such as may be prescribed. The subscriber or intermediary or any person in charge of the computer resource shall, when called upon by any agency which has been directed under subsection 1, extend all facilities and technical assistance to provide access to or secure access to the computer resource generating, transmitting, receiving or storing such information, or intercept or monitor or decrypt the information as the case may be. Provide information stored in the computer resource. The subscriber or intermediary or any person who fails to assist the agency referred to in subsection 3 shall be punished with an imprisonment for a term which may extend to 7 years and shall also be liable to fine. Some recent commentary on the amendment to the Information Technology Act has claimed that the amendments are little different from the powers already with the state in the Indian Telegraph Act of 1885, and thus civil liberties concerns are mistaken. This is not correct. Section 69 of the Information Technology Act 2008, passed by the Parliament on December 23, 2008, is far more intrusive than the Indian Telegraph Act of 1885, which was drafted to protect the interest of the British Raj. Under the new Act, IT Act, any government official or policeman will be able to listen to all your phone calls, read your SMS and emails and monitor the websites you visit, and he will not require any warrant from the magistrate to do so. Until the passage of the amended IT Act, phone tapping was governed by the clause 5 subclause 2 of the Indian Telegraph Act of 1885, which said that on the occurrence of any public emergency or in the interest of public safety, the government, if satisfied that it is necessary or expedient so to do in the interest of the sovereignty and integrity of India, the security of the state, friendly relation with the foreign state, or public order for preventing incitement to the commission of an offence for reasons to be recorded in writing by order, direct that any message or class of messages to or from any person or class of persons or relating to any particular subject brought for the transmission by or transmitted or received by any telegraph shall not be transmitted or shall be intercepted or detained or shall be disclosed to the government making the order or an officer therefore mentioned in the order. Other section of the Act mentioned that the government should formulate precautions to be taken for preventing the improper interception or disclosure of messages. Many calls have been made both inside and outside Parliament to formulate rules to govern the operation of clause 5 subclause 2, but ever since Act 1885, no government has formulated any such precaution, since all the governments have wanted to retain the right to spy on their opponents unfettered. A writ petition was filed in the Supreme Court in 1991 by People's Union for Civil Liberty, challenging the constitutional validity of clause 5 subclause 2. The petition argued that it infringed the constitutional right to freedom of speech and expression and right to life and personal liberty. In December 1996, the Supreme Court delivered its judgment. It pointed out that unless a public emergency has occurred or the interest of the public safety demands, the authorities have no jurisdiction to exercise the powers given them under section 5 subclause 2. They went on to define them. Thus, a public emergency was the prevailing of a sudden condition or state of affairs affecting the people at large. Calling for immediate action and public safety means state or condition of freedom from danger or risk from the people at large. Without those two, however necessary or expedient, it could not do so. But section 69 of the amended IT Act drops all the relevance to the public emergency or public safety, meaning that government's power have been vastly extended. The earlier Act, IT Act of 2000, mentioned only decryption of messages, interception and monitoring were not mentioned at all. Section 69 of new IT Act enhances the scope from the 2000 version to include interception and monitoring. It also broadens the scope of surveillance to include the investigation of any offence, whether cognizable or not. In view of the many incidents of tapping of the phones, politicians, the Supreme Court in PUCL case laid down procedures and guidelines to protect citizens against arbitrary exercise of power by the government. But this judgment, as well as the relevant sections of the Telegraph Act, has become infructuous with the passage of the amended IT Act, since the latter has overriding effect. And what of the safeguards in the Act? Well, when the government has not formulated any safeguards through Section 5 of the Telegraph Act since independence, it is unrealistic to expect it to formulate any safeguard under Section 69 subclause 2 of the amended IT Act, especially in view of prevailing terrorism situation. Until suitable safeguards are in place, Section 69 of Information Technology Amendment Act of 2000 appears to be in violation of Article 21 of the Constitution. No person shall be deprived of his life or personal liberty except according to the procedure established by the law. It is unfortunate that a democratic and independent India has passed a law which is far more detrimental to personal liberty than the British Raj did. Power to issue direction for blocking for public access of any information through any computer resource. Section 69 subclause A, where the central government or any of its officer specially authorized by it in this behalf is satisfied that it is necessary or expedient so to do in the interest of sovereignty and integrity of India, defense of India, security of the state, friendly relation with foreign states, or public order, for preventing incitement to the commission of any cognizable offence relating to above, it may subject the provision of subsection 2 for reasons to be recorded in writing by order direct any agency of the government or intermediary to block access by the public or cause to be blocked or accessed by public any information generated, transmitted, received, stored or hosted in any computer resource. The procedure and safeguards subject to which such blocking for access by the public may be carried out shall be such as may be prescribed. The intermediary who fails to comply with the direction issued under subsection 1 shall be punished with an imprisonment for a term which may extend to 7 years and also be liable to fine. Power to authorize to monitor and collect traffic data or information through any computer resource for cyber security is defined in Section 69 subclause B. The central government may to enhance cyber security and for identification, analysis and prevention of any intrusion or spread of computer contaminant in the country by notification in the official gazette authorize any agency of the government to monitor and collect traffic data or information generated, transmitted, received or stored in any computer resource. The intermediary or any person in charge of the computer resource shall, when called upon by the agency which has been authorized under subsection 1, provide technical assistance and extend all facilities to such agency to enable online access or to secure provide online access to the computer resource generating, transmitting, receiving or storing such traffic data or information. The procedure and safeguards for monitoring and collecting traffic data or information shall be such as may be prescribed. Any intermediary who intentionally or knowingly contravenes the provision of subsection 2 shall be punished with an imprisonment for a term which may extend to 3 years and shall also be liable to fine. For the explanation of this section, computer contaminant means shall have the same meaning assigned to in which is defined under section 43. Traffic data means any data identifying or purporting to identify any person, computer system or computer network or location to or from which the communication is or may be transmitted and includes communication origin, destination, route, time, date, size, duration or type of underlying service of any other information. In concluding remarks, we can say lawful interception is obtaining communication network data pursuant to the lawful authority for the purpose of analysis or evidence. Such data generally consist of signaling or network management information, or in fewer instances the content of the communication. If the data is not obtained in real time, the activity is referred to as access to retained data. There are many bases for this activity that include infrastructure protection and cyber security. In general, operator of public network infrastructure can undertake lawful interception activities. For those purposes, operators of private networks infrastructures have an inherent right to maintain lawful interception capabilities within their own networks unless otherwise prohibited. One of the bases for the lawful interception of telecommunication by law enforcement agencies, regulatory or administrative agencies and the intelligence services in accordance with the local law under some legal system. Implementation, particularly real-time access content, may require due process and receiving proper authorization from competent authorities. An activity that was formerly known as wiretapping and has existed since the inception of electronic communications. The material below primarily treats this narrow segment of lawful interception. Thank you viewers for watching this program.